Can someone? Okay, thank you, Fen. I was like, can someone answer?
Yeah.
Okay, so we'll get started then. So I want to thank my very special guest today. He is a Wisconsin criminal defense attorney, and his name is Michael Cicchini. Am I saying that right?
That's right. You got it.
Yes, yes. And he has written. He's written a lot of books, but he's written 2 books on the case, and they are Convicting Avery. I can't remember the exact tagline, and I just closed it. The bizarre laws and you got it in front of you, Mike?
Yeah, I've got it here. I would have forgotten it too. Bizarre laws and broken system behind making a murderer.
That's it. I had it open purposely, but I had to close it to find this my notes. And then Anatomy of a False Confession is the more recent one. And
That's right. That's about the Dassey case.
Right. And I already talked to people earlier today because I had to kill some time then too. And I had said that I have only had the chance to read the first one, but I've read it twice. And I really am glad that I actually had you on. So I had a reason to read it twice because I realized that when I first read it, this was like 3 years ago, right? When it was released. When I first read it then, obviously, I mean, I've already been working with the judicial system and I'm used to the courts and everything, but I had such a different perspective on it 3 years later going through the appellate system with these guys. It's just a much...
Right. Yeah, we in law school, where we read these great appellate decisions that are well-reasoned and apply the law, and then maybe your experience is the same as mine, that these appellate decisions often just rubber stamp whatever happens down at the trial court level.
Right. And I did tell people a little bit about what we were going to talk about. First, I just want to make sure that I tell everyone I do highly recommend the book, especially if you're interested in the law. I said that it might not make you very happy.
Right.
But it's very informative. And even if it makes you a little crazy because it seems so ridiculous, that it's still very informative. It helps you understand, if I can put that in quotes, understand our legal system. So before we get started, though, why don't you just tell us a little bit about yourself so they know who they're listening to?
Sure. Yeah, I practice criminal defense here in Kenosha, Wisconsin, which is a couple hours south of Manitowoc, where all the events unfolded from the Avery and Dassey cases. I do almost exclusively trial level work. So while I certainly read every appellate decision that comes down, I have very limited experience in the post-conviction world. So in other words, everything I do is at the trial court level, pre-trial motions to suppress, jury trials, and in some cases sentencing hearings, and everything that happens down at the trial court level. And then I also write. One of the things that I found, and what I want to do with the Avery book, and in fact the book I wrote long before Making a Murderer came out, is I wanted to bring to everyone and show them what's actually happening. The things that happened in Avery's case were not unique. Sure, they targeted Avery, but they didn't really treat him differently from every other defendant that they get in their sights. The things that happened to Avery, pre-trial and trial, that happens all the time, and that's what I wanted to do with the Avery book. I thought that was because there was such interest in the Wisconsin criminal justice system because of that Avery case. I wanted to kind of expose what was happening, what did happen to Avery, and what happens routinely every day. The only difference is that it's usually not a homicide case or a murder case. That's really rare compared to all the other crimes that are charged. So that's really the big difference between Avery's case and what happens every day in the criminal justice system here in Wisconsin and elsewhere. Wisconsin isn't unique. I think it's extreme in some cases, but certainly there are other examples from other states that are equally bad. But because I practice here, I focus on Wisconsin, and all of my articles, most of my articles in all of the books certainly have some tie-in, if not an exclusive tie-in to Wisconsin law.
Now, did you always know that you wanted to be a criminal defense attorney?
No. I was a CPA before going to law school. I thought I was going to be a tax lawyer or a business lawyer.
Okay.
And I did go to a big firm for a couple of years after law school, a big firm in Milwaukee. Worked there for a couple of years and then still didn't think I was going to be a criminal defense lawyer. I started my own practice, and I thought, well, to get some courtroom experience, I'll take some public defender appointments. And once I started doing those, I got kind of, I guess you could say, sucked in. I haven't done anything since. And that was about 18, 19 years ago now. So, no, I had no intention to be a criminal defense lawyer. Didn't have any interest in it at all. Didn't even know that world existed other than a course or two that I took in law school. And it was just by chance, really, that I ended up kind of stumbled into it. And here I am today.
Wow. Now, what did you know about the Avery case, or about Steve Avery in general, before you watched Making a Murder?
Yeah, not a lot. I don't even, let's see, the case was, what year was his first trial was in the 80s. So I definitely wouldn't have known about that. And when was his second? Well, yeah, the first one I definitely didn't know about. I knew a little bit about the second one, but not a lot. I mean, it wasn't really high on my radar. We heard about it a little bit until I, like everyone else, kind of got drawn into it with the documentary. And I didn't even watch it at first. I had no intention of watching it. And then everyone kept talking about it, how great it was. And I thought, well, I generally don't like law shows, but this is a documentary, so I'll give it a shot. And I did. And so I was kind of drawn into it at the same time as everyone else. I had been practicing a long time, by that point in time. But as far as that specific case, I was kind of drawn in along with the rest of you.
Now, when you watched it, were you shocked, or were you just watching and being like, yep, that sounds about right?
Yeah, there was no shock at all. I mean, in fact, almost immediately, I got excited about a book idea because I had written books before. And when I remember, I couldn't cite the exact episode now, but I remember Jerry Buting was talking about, we'll see how good my memory here is. Maybe people can either call me on this or confirm it. But my memory, as I sit here today, I remember when Jerry Buting brought up the topic of the third-party defense.
Right.
I thought, oh, wow, this is just begging for a book to expose these different things. I mean, and there were problems with Wisconsin's various flaws were put on full display. One, the law on third-party defense, and what that is where a defendant wants to say, hey, not only am I innocent, but I know who did this crime. And the law it's very difficult to bring in other suspects on a case,
right,
to point the finger. So that was the thing that kind of, I'll use the word, triggered my idea that said, well, okay, I've now got to start taking notes and watch this with a book in mind, because I wanted to bring out all the different flaws of Wisconsin's system that kind of were a little bit under the surface. Making a Murder did a great job, and it wasn't designed to be an expose on Wisconsin law. So that's what I wanted to do, was kind of bring out all the nuances and the problems with Wisconsin law that were kind of featured in the documentary. And those are things that I had run into repeatedly up to that point. So no, it wasn't any surprise at all.
Right.
And I would imagine that, although murder cases are rare, I would imagine a person charged with the more serious crime, the judges are going to be more critical of them, and they're going to have, paradoxically, even though you're charged with a more serious crime, I think you're going to have fewer rights, or at least your rights are not going to be enforced. You're not going to be able to exercise those rights as well. So no surprises there. And once I got into it an episode or two, that's when I realized, yeah, this is begging for a book.
Yeah, and unfortunately I knew you were going to say that. I wish I could say that I thought you'd be shocked by it.
Right.
But because of the culture in general and just, how the court system works, and I just was like, yep, he's not. That's why I asked the question that way. He'll be like, yep, that sounds all right.
Yeah, right. I guess I am a little shocked at the popularity of the documentary. I mean, It was really well done. But there had been others before. I don't know. I don't know much about film. I don't know what exactly was different about this one. But I think, like everyone else, I was a little surprised by the huge international following that it got. So that was a bit of a surprise. But certainly nothing about what went on in the courtroom was a surprise.
Right, because it wasn't surprising to me that I knew a lot of people that watched it because we're in Wisconsin. So
right.
Of course, we were like, hey, we got to watch this. And some of us at least had heard. I didn't know a lot about the case at all at the time. I'd heard, probably like you said, I'd heard a little bit about it, but I really didn't know. And unlike what the attorneys say, to me, this was not like statewide news every day. It was not, it just, I believe that it was absolutely all over the news in those small counties there.
Right.
But in Milwaukee, no. There's a murder every day in Milwaukee, or two every day, so they try to give this impression that it was like, oh, everybody heard the case, we couldn't get a fair trial anywhere. And I've kind of always taken issue with that, because I'm like, I think you could have got a fair trial in Milwaukee County easily.
Yeah, we see that a lot in cases when I try a case down here that's been in the local news. It's amazing how many people even here don't know anything about it. So yeah, I would think certainly in those communities it would have been saturated, but I agree, as you move away, it might have been, you're going to get less and less exposure to it.
Right. Now, okay, so I kind of want to go just like through the book. We kind of jumped around a little bit, but I figured the best way is to kind of just move through it linear. I can't even talk right now. I haven't slept, so I'm not going to try to say it
Sure, sure.
linearly. And I thought it was funny that the very first chapter is titled "Welcome to the Hellmouth."
Yeah,
First
that's
off,
a Buffy the Vampire
right, I just
Slayer
say first
reference
off,
for those.
I'm a Buffy fan, so I can appreciate
Yeah,
that. But of course, you're referring to the justice system in Wisconsin, and you kind of touched on this a minute ago. But my first thought was, are we really that bad compared to other states?
yeah. It's tough to know. You know, one of the problems with law schools is they teach kind of a national body of law, like you'll learn from these model codes and things. And the reality is, in practice, especially in criminal law, criminal procedure, it's dramatically different by state. So certainly there are disasters in other states. You might recall hearing about California's three strikes law.
Mm-hmm.
But that was a disastrous thing in the context of sentencing. And then like the third party defense, I've written an article on that. Um, that's posted on my website. It's up there in full text. Anybody can see it. It's free for anyone who wants to read it. Another name for that is the wrong person defense, third party defense, wrong person defense. That's pretty similar throughout the states as far as it's difficult to get that in. So some states in some ways are as bad, some are worse in some regards. But I think, and I'll admit, when I did write that, I mean, part of the problem, not problem, but part of the reason I look at it that way is because state law is so specific and you're licensed by state, I'm only exposed to Wisconsin criminal law for the most part. But there are some truly bizarre things that happen here. The one, you know, we had a prosecutor threatening to school. I wrote about this in the book. It's been a while, but a prosecutor was threatening to sue school teachers who or threatened to prosecute them criminally for teaching the state-approved curriculum on sex education. You know, that's just really bizarre that you could, you know, be prosecuted criminal or have to live under that threat. I think the prosecutors in our state, in many cases, are, you know, kind of carefree with their charging. You know, they don't have to live with the consequences of it. And it's, so I would say Wisconsin certainly in many ways is among the worst of the states.
Now, going back to the 1985 case, I mean, the Holdover case makes us shake our head constantly every day. But with the 1985 case, you look at it and you had one eyewitness account that was tainted by law enforcement versus 16 alibi witnesses and no physical evidence connecting Steve to the crime. And so people want to know, like, how does that happen? How can you convict somebody on that?
Yeah, I think that comes down to the power of the eyewitness identification. You had a likable, sympathetic victim. She really was a victim. I hate using that word, and it's overused in our state. We anoint people victims before the case even gets to trial. But in that case, she clearly was a victim. The only question is who was the perpetrator. So she was likable. She swore. The police built up her confidence in identifying Avery. And I think psychologically, that's what carries the day. It's really amazing how certain things can be persuasive, even though logically they shouldn't be. But the human mind is, you know, odd that way. Jurors find one of the most persuasive things is obviously a confession, as we learned from the Dassey case. And probably the second most persuasive thing is a confident eyewitness, even though confidence is not correlated with accuracy in many cases. So there are a lot of studies on that. So it's a matter of what the human brain is appealing to the human brain, but that doesn't necessarily mean it's proof. And I think in that case, it was a combination of that, the sympathetic and trustworthy eyewitness, you know, and victim. And police like to paint it as, well, she has no reason to lie, therefore it's true. Well, the issue wasn't whether she was lying. Those things really did happen to her, and she probably did believe that Stephen Avery was the perpetrator. But that belief was tainted by the police multiple identification procedures, which kept reinforcing her strong beliefs that Avery was the perpetrator. So that's a really bizarre one. It's really frustrating. And we've had, even in Wisconsin, some changes in eyewitness identification laws since then. I think it's just the power of that witness getting up there and testifying confidently. People like to believe that. And the human brain just kind of gravitates toward that. And I think we tend to accord too much weight to that type of evidence. You brought up a good point there. Avery had the stronger case by far. Multiple alibi witnesses. If I recall, I think he even had documents that proved he was making a purchase
he had receipts.
far away.
Yeah, he had receipts, and I believe a camera even caught him.
Okay, yeah, I wasn't aware of that, or if I was, I forgot about it, but I know there was some proof that he was far away at the time. Multiple eyewitnesses, lack of physical evidence. When you combine that with the burden of proof, that should have been a slam dunk acquittal. But, that's the risk. I think it was multiple factors. The police, I'll call it misconduct. I don't know if they, often those things happen unintentionally, but certainly the police did not handle the identification procedures well. Prosecutor, willing to pursue a case when all the evidence shows otherwise, and the powerful nature of the eyewitness, the victim's testimony, all those things I think kind of combined. That's what we have, and that's not an uncommon case. That happens. Eyewitness identifications result in a lot of wrongful convictions throughout the country. That's not a problem, obviously unique to Wisconsin. Eyewitnesses are the same regardless of the state they're in, and their weaknesses are the same. So yeah, it's a big problem.
So it's already bad enough that they were able to convict him, but to make things even more crazy, he was allowed to do DNA testing of fingernail scrapings underneath her fingernails. And even after the results excluded both him and her, they still would not overturn his conviction.
Right, exactly. You can just, and when you read that opinion, you can just see how they're just torturing logic to get their predetermined outcome, which is affirming the conviction. There was one other thing that sticks out in my mind from that. When they affirmed that conviction, and this shows the dangers of speaking to the police, they even used Avery's words at the time of his arrest as evidence of his guilt. He said something like, well, they told him there was a murder, and he says, well, where does the lady live? He obviously assumed the murder victim was a woman. And they used that as evidence to corroborate the guilty verdict, as corroborating evidence of the witness's identification. They said that, well, how would he know that it's a woman if he wasn't there and did it? Well, the answer is simple. He took a stab. Probably most murder victims are women. At least he thought that. Whether it's true or not, that's something he thought. But yet, that just shows the danger of talking to the police. Even when you're doing it in good faith and you think they're acting in good faith and trying to get to the bottom of what's happening, they can take anything you say and use it. Next thing you know, on appeal, now you've got DNA evidence, like you said, under the fingernails. It shows it's not you. And now they're using your statements that you made at the time of your arrest to uphold the conviction. So there were a number of problematic things happening there from the standpoint of the appellate courts.
So let's talk about the appellate courts once, because one of the things that I've had a really hard time making people understand, and I understand why, is that appellate judges are never going to second guess a verdict. That's not what they do.
Right.
It's
incredibly rare that a case will be overturned. I can think of, I've read every non-traffic case. In other words, I don't read OWI appeals or appellate decisions. Other than that, I've probably read 90 to 95% of the cases that have been issued since I've been practicing, and I can think of one where they reversed a jury just for a complete lack of evidence. And that's probably the rarest thing you'll ever find in an appeal. So you're spot on. The appellate courts are not going to second guess a jury's verdict. They'll look for anything, no matter how small or slight, to support it, and then they will affirm. So that's why I don't think many appellate lawyers really hold out hope that they're going to get a reversal on that ground.
I obviously talk to people a lot about this case and about the law, and they always have a problem with the fact that they can't understand how the judges don't see it as we see it, because it's so obvious to us that there's all of these problems. And yet a judge can look at it and be like, no, nothing to see here. Like,
yeah, you almost wonder if they really believe that, or if I can't get inside their minds, but certainly they're political creatures. They're elected. Nobody, look at what happened. There was a justice named Butler on the Supreme Court, and a guy named, I don't think he's on the court anymore, Gableman ran against him. And Butler once dissented in an opinion in a homicide case because it was a clear confrontation violation. By that I mean the confrontation clause. And he he just rammed that down Butler's throat through the political campaign process and the ads, and just bent it out of proportion. And we live in a society, I think, where a soundbite will carry the day, whether it's true or not. And I think that's one of the risks. I think a lot of these appellate judges, similar to a lot of trial court judges, not all, but certainly many, are just not interested in the law. I've never seen, there's a great level of, I will call it complete disinterest in the law. You can tell their decisions are made beforehand, and they often don't even provide a reason for their decisions. You could kind of see that in some of the appeals cases, with Avery. They give a whole, or I should say, take Dassey's appellate case. They give 2 paragraphs. That's it. I mean, that was just cutting and pasting some basic things, basic principles of law, and something from the trial court's decision. And the mind's made up. I think you can't deny that. I think in a lot of cases the mind is made up. A bad man has been convicted, and the mind's made up that we're going to affirm that conviction. And I don't know of any other way to explain it. I do know that legal reasoning is really lacking in our courts. Courts.
The one thing that there seems to be absolutely no room for whatsoever in the judicial system is common sense.
Well, I guess I see what you're saying when you mean common sense. Yeah, I sure you could call it that. I think even more than that, you think they're trained in the law, they should be applying the law.
Well, I was going to ask you,
apply the law to some of these cases. The outcome is obvious. Like you said, people get frustrated because they don't understand how it's a different way. I think a lot of these things you almost have to be outcome oriented. If you know the outcome you want, then it really doesn't matter what you say to get there, and that's what you see in a lot of these decisions.
Right, and it's very disheartening that even if on paper it seems like the law is on your side, there's always a loophole, an exception, some type of legal gymnastics that will allow a judge to rule against you.
Yeah, and they'll just torture the language. They'll create exceptions. They will bend logic to the point where it's unrecognizable. And this is at the trial court level as well. So I deal with all of this frequently as well. And it's almost shocking when you get I can remember one time, I rarely travel out of county. I've only been out of Kenosha County maybe 3 or 4 times at most. And I remember one judge in another county, he told me, okay, I raised a multi-point motion, and he wanted argument on the first point. I started to jump into the second point. He stopped me, and he said, I just wanted the first point. I said, oh, I'm sorry. So he denied my motion. Then he let me argue the second point. And I did, and the prosecutor did, and then he rigorously applied the law, went through it, did the balancing test, all the different things, and he granted the motion. And it was so shocking. When you actually get a judge who is logical, structured, applies the law, it's really a shock. So that's not the norm, unfortunately. If anyone is listening as a law student and they're about to go into law, particularly criminal defense, they might experience that for themselves. I think that it's probably more common in criminal defense than criminal law because there's more emotion there. We want to get the guy and keep him in prison type of thing. Whereas if you're dealing with 2 corporations suing each other, there might be less emotion and judges might be more likely to follow the law. That's my untested theory anyhow.
Well, one of the words that we use a lot when discussing the state's actions in this case is disingenuous. And it was funny how many times I saw you use that word in your book. One time you described the legal double talk we were just talking about as disingenuous nonsense. And I was like, yes, that's exactly how we feel every time we read something.
In my perspective coming into this, I remember the first time I was victimized by this in the courtroom. I was just in pure shock. I couldn't believe it. What had just happened. It was a suppression motion, and I had this cop dead to rights with his recorded statements to the dispatcher. It doesn't matter the details. The point is, when I first saw this disingenuous, I couldn't believe it. I mean, when I entered this, I certainly didn't expect it. Like I said, I was a CPA. I had worked in accounting. I was very logical. I figured my view was, well, I'm going to do criminal defense. Surely the prosecutors would never charge someone unless they had a really strong case. So I'll still play an important function, holding the state to its burden of proof. Every once in a while, I'm sure there might be the prosecutor might make a bad charging decision. It was a complete shock to me, and I was not a liberal. I was not a social activist of any kind. So I was just what I would describe as just a kind of a rational thinking person, and as I think most of your viewers or listeners are today, and it was a big shock to me. It was hard to adjust to.
How can any defendant get a fair shake when it seems like the first thing a judge thinks when looking at an appellate brief is, what excuse can I come up with to deny this, as opposed to evaluating everything with a fair-minded jurist's eye?
Well, we really are kind of limited by our judges in a lot of ways. I think the one time you can get a fair shake is, now we've just established, though, that sometimes jurors don't make good decisions, like in Avery's first case. But I think the one case where you can get a real fair shake is if you've got a trial that's a simple he said versus he said, or he said, she said, or something like that. Things that fall so squarely within the law, like cross-examining a witness with their one of the state's witnesses with their prior convictions or something. I mean, in certain cases, they're so simple that you feel like, okay, no judge can take this away from me. We're going to be able to put on our case. In other cases, if you want to bring in something like a third-party defense, there's virtually no way. You just almost have to get lucky, get the right judge, or substitute on the judge and hopefully get the right judge. And there's no way you can guarantee it, for a client. I think that's exacerbated here in Wisconsin because of many of our rules.
Is there any word in the judicial lexicon that is more hated by defense attorneys than the word reasonable?
Oh, right. Yeah. That's reasonable is subject to unreasonable interpretation.
Right.
So, yeah, anytime there's a multi-factor balancing test, or the judge has to decide something on reasonableness, you can say that safely 9 out of 10 times the defense will lose. Whenever there's tremendous leeway granted to the judges, you're in trouble. Reasonable is that key word that you need to look out for, because it means the exact opposite of what it says. So you're on the ropes already if you're a defense lawyer and that issue comes up at some point, unless it's an issue to the jury. If you're arguing that reasonableness is one of the elements of the crime, or something like that, then you got a shot.
So, okay, I found it interesting, and you mentioned it a little while ago, that when you were giving some of your examples, which I already told people before you came on, that one of the things I did like about your book was that you try very hard to make sure you put it into context that a layperson can understand. You put it like, okay, so for example, this is what happens. But one of the things you would say on at least a couple of occasions was, but the judge didn't know the law, and so he got it wrong. And of course, I sit there thinking, wait a minute, how can a judge not know the law and have it wrong?
Yeah, that's the frustrating part. Like I mentioned before, many judges are just completely disinterested in the law, and it's an uphill battle. There's many ways we defense lawyers in the state, and I say we, I kind of have an idea of what we're all up to, because we all, the more serious ones at least, joined in the Wisconsin Association of Criminal Defense Lawyers. So, we kind of communicate a bit that way. But there's many ways we try every case. We find we have to educate the judges on certain legal issues. We can file motions in limine, which means, well, okay, we're going to bring up this really basic legal issue, but let's put it in the motion, bring it up, get a ruling beforehand, so the judge isn't surprised by it mid-trial, even though it's a pretty basic issue. We can't take the chance. That's one way we try and educate the judges.
But
Another way is what we call.
That's so backwards that you would even say, like, we have to educate the judges. Why are the lawyers having to educate the judges? I mean, shouldn't they?
Yeah, it's really frustrating. Similarly, along those same lines, since you've read a lot of appellate cases and you probably saw the topic of ineffective assistance of counsel come up, we not only have to educate the judges, but if the judges commit some form of misconduct during the trial, or whether intentional or just negligent from ignorance of the law, if we don't stop and police the referee, if you want to call the judge a referee, if we don't stop and referee the referee and make an objection or make an offer of proof or do everything just right, we get blamed. The defense lawyer, the trial lawyer, get blamed under the ineffective assistance of counsel doctrine for not doing the judge's job. And that same thing applies to the prosecutor. If the prosecutor cheats in closing argument, if anyone's interested, I wrote a recent article on prosecutor misconduct in closing arguments. And if the defense lawyer doesn't jump in and do just the right things on a moment's notice, and then it's on appeal, it's going to be the defense lawyer who's been blamed for ineffective assistance for not policing the prosecutor. So it's really a tough job in that regard. You have to do three jobs in one. You have to watch the prosecutor, make sure he or she isn't cheating, and then you have to watch the judge and make sure he or she is doing everything. So it's a lot of work, and it creates a lot of anxiety, when doing one of these cases. So you have to prep not only for what should happen, for what your witnesses are going to say or do, but you have to anticipate all these different avenues of where things can go wrong, and that's where it gets complicated.
Okay, so going back to the Hallback case a little bit, because there's certain issues that I want to talk about, because one of the things I told you right off the bat was that I had been talking for a long time about sort of doing a PSA on, knowing your rights, because it is so shocking to me, even after watching Making a Murder, how many people really don't understand their rights. And we're talking about adults, not just, juveniles.
Right.
And so the first thing I wanted to talk about, though, was with the Hallback case, because this is right in the beginning.
Yep.
How were they allowed to search that trailer so many times? It was a trailer. It wasn't the Taj Mahal. How were they allowed to legally search that trailer so many times?
Well, the Fourth Amendment is one of the toughest, I would say, the toughest way to get any type of relief. And one of the reasons, I'll get to your specific question in a second. One of the reasons is the good faith exception. Even if the police violate the law, they say that suppression of any evidence, which is the obvious remedy, right? If your rights are violated, what do you want to do? And they find a marijuana cigarette in your house. What do you want to do? You want to suppress the evidence. Without the evidence, they can't prosecute you. The law says that, suppression of the evidence is not our first resort. It's our last remedy. So even if you can prove a Fourth Amendment violation, you're not likely to get any remedy. Now, in that case, we talked about the tortured language, tortured logic, and the use of the word reasonable. The courts just created new exceptions. I mean, there's a rule that says they can't, they have a warrant. Generally, it's one warrant, one search. They can't hold your house hostage and keep you out of your home and search it repeatedly for days on end. And you'll have to forgive me, I don't remember the exact language that the courts used in defining that, but they just created new exceptions or excuses. I think the better word is just creating excuses for them, and they accepted, they ignored the words and the testimony on the issue from the police officers on the ground and decided, and they selected which language they wanted to rely upon. And they didn't come up with anything logical or coherent. It was just a mishmash of gibberish, and they said, "Yep, motion denied," and that would have been at the trial court level. Of course, on appeal, they would be upholding the motion. When you're moving to suppress, you first bring a motion to the trial judge. He denies it, and then you appeal that decision up to the appellate courts, typically after a conviction. So there's no, when you look for a logical answer or a specific sub-rule or a specific exception to the rule, there really isn't one. It's just kind of made up. I can't explain it any better. I certainly do in the book walk through it and use the what I'll loosely call reasoning of the appellate courts, but there's no real satisfactory answer to your question.
Yeah, I already knew there wasn't. But for me, I'm asking questions I know the answer to, but these are the types of questions that I get asked by other people.
Right.
Every day I see these same questions. And I figure maybe hearing it from you in a different way will look
yeah, and I'd say, if anyone is interested in that, I did put a chapter in there on it and quote extensively from the appellate court record. Of course, since I've written that, I've read hundreds of cases. I don't have a real firm recall of all the facts, but it's amazing when you just see them twist and turn. And if you don't believe me, you don't even have to buy the book. Go and pull up the appellate case. You can get it for free online and just look at what they're doing and saying. It's just unbelievable. And if you really want a full picture, it's absolutely free. If you go to Wisconsin Appellate Court Access, you can pull up not only the appellate court decisions, but all the parties' briefs. So you can pull up the defense brief, and then you can read the court decision, and then you really get a picture for, wow, what are they doing?
Yeah.
And you can tell. The only way to explain it is to say that it's outcome. The outcome's already been determined before they put pen to pencil or fingers to keyboard. That's really the only explanation I can
Right, and
conjure up
that's
for this.
exactly what we're seeing, because it's funny when you say, if you want to go look at these, okay, everybody in this chat right now has read everything in this case, probably.
Right, right.
Yeah,
Yeah,
so
I mean, they know. I mean, just look at it. Look at the what they call what flies for reasoning. I mean, I often use the analogy. I've been tempted to say it a couple times. I haven't yet mustered the courage in the trial court level to tell the judge that the prosecutor's argument wouldn't even pass a law school exam. And I don't want to cross that line and do it, but it's true. And then judges just adopt that. So that's the way of it. There's just it seems I mentioned somewhere, I don't remember which, it might have been in the Dassey book, how it's in some ways we really can't even call the law a profession, because I almost wonder if having gone to law school really has any effect on your legal reasoning, because even if it did when you start, it's all quickly forgotten or tossed away if you become a prosecutor or a judge. And not all of them, by the way. I mean, that should be obvious. I don't mean to say all prosecutors and judges are like that by any stretch, but it's a common phenomenon that I'm seeing all too often.
okay, so I didn't want to go into the specifics of Brendan's confession, all that, because we have done that to death. There is
Right.
like, everybody understands how they got a false confession. They understand the tactics. They understand the conditioning that was used and the trickery that was used. So I want to go into some other aspects of that.
Sure.
Now, we talked about a little bit of email, and I said that this is where I say I want people to know what their rights are. One of the things that people do not always understand, and I blame this on TV and movies, is that law enforcement does not have to Mirandize you when they arrest you, correct? So what is the reason why they wouldn't Mirandize you?
Well, they want you to talk. I mean, on TV, you're right. If for some reason TV has picked up this theme, and you see it all the time, the police, it's the first thing they say. They use it like a victory speech. They start reading Miranda. The last thing they want to do is read Miranda, because they want the person to talk. Often they don't have a case, or don't have a very strong case, so they want a confession. This is bizarre to me, but people love to talk, and they want to talk, and silence is difficult for them sometimes. So they only have to read you your rights if two things are true: you're in custody, and you're being interrogated. So just because you're in custody doesn't mean they have to read your rights. They can sit back, say nothing, and hope you start talking. And they can even find ways to kind of violate that. They can say things designed to get you talking that aren't technically questions, and then there's litigation about that. But
Right.
The defense often loses those.
I mean, I talked about that once. I said that to people. I said, you do see this on TV, and this is actually one of those things that is true. That they'll say, okay, we're not going to ask you any more questions. And then you have the two cops talking to each other, and then it's like they're trying to just get you to say something. Now, would that be considered then an implied waiver, because you said you were going to remain silent, but you didn't? So you changed your mind.
Oh, so you're talking about after, if a person invokes their Miranda rights,
if they Miranda,
talk to each other?
Yeah, because they still try to do the same. They use the same type of trickery that they're like, okay, you said you weren't going to
talk.
Yeah,
that can be done after or before. They could simply say, well, he invoked his rights, so we stopped questioning him, and then we were just talking. And then, the guy, he decided to reverse his invocation, and he started talking. We didn't ask him any questions, and that's certainly a trick in their bag. One of my favorite examples is an old Wisconsin case where a guy was charged with a type of a forgery type crime, and the cop sat down next to him and just started talking, and then asked him, well, how did you do it? And very pointed questions, and the court said, well, that really wasn't questioning, that was just engaging in shop talk. So the courts will kind of twist the language any way they want to find that there was no questioning, or to find that there was no invocation of the rights, or to find that the person wasn't under arrest. Whenever you have these different prongs of the exam of the test, he has to be under arrest, there has to be questioning, and so forth. That's where the litigation happens. So the question will become, well, sure, he was in a small interrogation room and the police were blocking the door, but they didn't read him his rights, but he wasn't in custody. He should have felt free to leave, or a reasonable person would feel free to leave. There's that word reasonable again. So whenever you see those different prongs or those different elements of the test, that's where the litigation happens, and that's where the courts will twist the language to suit their predetermined outcome.
Right. And again, another one of the things that I've explained a lot that I know that people don't understand is they think once they hear those Miranda rights, they can't leave. And unless you're under arrest, you can leave.
Yeah, the cops may give you Miranda warnings when you're not under arrest, although they don't have to unless you're in custody and being questioned. But you can certainly ask to leave at any point in time, and then you'll know if you're under arrest or not. But typically, if they follow the law, they're not going to read you Miranda rights unless you're in custody and they want to question you. So if they do, chances are you're not free to leave, and that's why they are reading the rights at that point. But still, people just feel the need to talk even after hearing that warning. It's amazing the high percentage of cases where when people do get a legal warning, it's a proper one, and they understand it, which isn't always the case. A lot of adults don't understand what some of the warnings mean, or the warnings are actually incomplete. They don't tell you what happens if you remain silent. A lot of people think, well, if I remain silent and ask for a lawyer, that's going to be used against me. Where if it's post-Miranda, that's not the case. If you invoke a lawyer, your right to remain silent after the Miranda warning, that's typically not the case. So it's a high waiver rate. A lot of people do waive their rights because the warning isn't effective at conveying those rights. That's one of the problems.
That was actually the next thing I was going to ask is, do you know how often people waive their rights?
Yeah, in studies, I did a study, I should say Larry White, psychologist, Beloit psychology professor. He was featured in Making a Murder episode 3, I think it was. He and I have done a lot of work on a couple of areas, Miranda and interrogations, and we've also done some work on this jury instruction issue here in Wisconsin.
Right.
And he and one of his students did a study of actual interrogations in Wisconsin, and they found and then we subsequently turned that into an article, which you can find on my website. It was published in the Idaho Law Review. And it's in the sample that they use, I think it was more than 90%. I think nationally it's more than 80% people waive their rights and talk. So it's a very, very high percentage. One of the reasons is people don't fully understand their rights, or, as I said, the rights are incomplete. They don't give a full picture of your options, really.
Now, again, I know this answer, and I'm sure a lot of people know this answer, but what about when the cops always say, well, this is your last chance to get the truth out there, or we can't help you, once you get a lawyer, or, it's only going to hurt you. It's going to make you look guilty if you get a lawyer instead of just talking to us. What about all those things? Because we know people fall for them.
Yeah, that's, those are certainly tricks that they'll use the most common thing is, hey, this is your opportunity. They paint what's a very big risk for you into an opportunity. Some courts will even say, or some police will even give a Miranda warning. One of the local departments around here does it. They say that anything you say can be used against you or for you in a court of law. And that is the rarest of cases where a defendant's statement could be used for him, because if a defense lawyer tries to introduce it, it's a statement of the client. It would be considered hearsay in most cases. I'm not saying these are generalizations, but it would be the rarest case where you could use your own statement for yourself in court. So that's misleading. So they're full of deception and false information when they try and get you to waive those rights. But their techniques are very effective given what we know in wide-scale national studies about this high waiver rate. I think that's not a Wisconsin-specific problem. That's a national problem.
And does it have any impact whatsoever on what a judge will say or what a jury will say if they find out that you lawyered up right away and refuse to talk?
No, as a general rule, if you are given a Miranda warning, you're under arrest, the police give you a Miranda warning, the general rule is they cannot use your post-Miranda silence or your post-Miranda request for an attorney against you. That would not be admissible against you in court. Now, this is going to be beyond what we want to talk about, but oddly, your pre-Miranda silence in some cases can be used against you. That's a completely different story. This is a very, complex. See, these different fact scenarios, these different distinctions in the law are created by the appellate courts when they're trying to find ways to affirm a conviction. But as a rule, once you're given your Miranda rights, you're in custody, you read Miranda, they want to question you, your request for an attorney or your decision to remain silent is not admissible against you in court, is the general rule.
Right. Now, we all know...
That can be, I'll just give one exception to that. If the defense attorney happens to argue, they didn't even ask my client anything like that, well, guess what? That's now likely going to come in and be used against you to rebut what the defense lawyer said. That's just one example. So there's never a clear-cut answer, a 100% answer to anything, put it that way.
Now, we know that investigators or interrogators can lie to suspects.
Right.
To
Right.
what extent can they take that lie? Like, they can't actually like falsify a document or like a forensic report, right?
That actually, that's a good question. That's something I'm looking into now in a case. I can't talk about pending cases,
Right.
but I know they can lie, they can fabricate evidence, they can. I don't see why they couldn't come up with a fabricated result. Like, well, we've got your DNA now, that we just ran a rapid DNA test. We got that technology, and it comes back positive. Your DNA is all over that. I don't see really why the courts would say that's not allowed when the police can fabricate eyewitness testimony and they can fabricate anything. So I'm not familiar with the law testing the limits of their lies. I know there was something written on it in the Wisconsin Law Review by Katie White. Actually, Larry White's daughter, I think, wrote something along those lines, and I'm going to have to research that myself. As you can see, we lawyers don't always have these answers at our fingertips because of these subtle nuances,
right,
that are created by the appellate court. So I'm not aware of any limit on on police lying. I hope one exists, and I'll soon be looking into that myself.
Well, you let me know when you find out. Because I thought that they couldn't falsify like an official report. That they could not do.
Yeah, I mean, could they lie about what's in it?
Yeah,
maybe?
So they say that your DNA was found here, but they can't show you a report saying this is your DNA and this is where it was found. That's why.
Yeah, I don't know. I've never seen that limit tested. I hope you're right. I've not come across that yet, and I hope to find out soon.
Let's see what else I had on here. Now I know you're not. It's not. I don't want you to like talk about the other lawyers because I'm sure you have a lot to say, but it's not good for you to say it. But just in general, have you ever seen a defense attorney and his investigator railroad their own clients?
Oh, right. No, I've never seen that before. I understand what the Cicchini's goal was, but I've never seen that before or anything close to it.
Especially with a 16-year-old.
Yeah, I mean, certainly, I don't mind. I just have to be careful. Obviously, I can't talk about my own cases,
right,
other than just generalities. But no, I certainly would never do that. The thing, I kind of discussed some of the ethics principles that came into play when I wrote the book. I discussed some different ethics rules that would have impacted the lawyer, and one of them is, if not an ethics rule, it's certainly a principle of law that the decision whether to go to trial or not is the client's. So I'm always careful to give my recommendation based on the evidence as I see it and the plea offer that's available, and I'll make my recommendation. But often clients will say, well, you're recommending a plea, but I want to go to trial. And often when I'm recommending a trial and almost begging them to go to trial, they are afraid and will want a plea. So I always respect that decision, and I never go to the extremes, to get a client to do one thing or the other, as was seen in Making a Murderer. I haven't heard of anyone doing that, and I've certainly never done it.
Well, while we're on the subject of ethics, how can you have a press conference like that and it did violate like so many ethics rules, but how could Kratz not get charged with any ethics violations?
Yeah, I'm always quick to point that out. I never want to accuse an attorney of an ethics violation. And
I will. I'll do it for you.
I don't think Kratz ever had one, as you just pointed out. I know he did have one, and it's public, and you can find it, but it's not related to Making a Murderer.
Right.
And I know and I don't think, I'm not aware of Cicchini having one either. So I'm always quick to say, because we lawyers can be, some of these ethics rules are just terrible and unconstitutional. And one of my legal reform initiatives that I tried to do in the past is to change Ethics Rule 1.9. It's an infringement on attorney-free speech. The state bar's position is that I cannot, or any lawyer cannot, talk about even the public aspects of their closed cases. So I believe that's an infringement of free speech. Other states have held that. So ethics rules are a landmine. They're an absolute landmine for lawyers. But, go ahead.
How could Jerry and Dean then go on Making a Murderer and talk about Steve's case if that's a
you can get? I suspect a couple of things. You can get a waiver from your client, and then the other thing is that it can be I suspect it was kind of implied because I'm sure these people that did the documentary got waivers from Stephen Avery, so I'm sure that he gave his permission.
Okay.
So that's the situation. What I'm referring to is Ethics Rule 1.9, say I handled the case that was in the newspapers, it's been closed for 3 years, and I want to talk about it. The state bar's position is that I can't. I disagree with that position. I think they're wrong, but that's their position. So my only point in bringing that up is that some of these ethics rules are just landmines for lawyers. Now, getting to your question about Kratz and the press conference, I would not have done such a thing, but there are conflicting ethics rules. One of them says that a prosecutor shall not disclose the contents of a confession of a suspect or a defendant, things like that. So you're right, it appears to clearly violate that rule. And then there are other more complicated possible exceptions to it. For example, it appears to me that once a prosecutor's assistant merely cuts and pastes part of that, puts it in a complaint, and then a paralegal or a prosecutor files that complaint, it's now a public record. It appears then that might bring it into the purview of things that you can't discuss because it's in a public record. And I think that was one of the things that Kratz raised, because I think there was some litigation on that in Avery's pretrial motions.
I mean, he obviously said that he could not get a fair trial, because of the pretrial publicity.
Because of the press conference, in part.
Right, and the press conference. That's why, because the press conference had tainted, and that's why Dean Strang has said Steve can't get a fair trial in any of the 72 counties in Wisconsin. And I still was like, don't believe that. But
right.
They were trying to get, basically like, well, you can't prosecute him because he can't get a fair trial now.
Yeah.
And it is. I mean, you watch, and it's so over the top.
Yeah, I call it as dramatic rendering. I mean, there's the well-timed pauses, obviously the overuse of the word sweat, which is kind of creepy. But it's over the top. It's dramatic. It's not. I certainly wouldn't have done it. But in his defense, I'll come to the aid of a fellow attorney, even Ken Kratz, that he was never found to have done anything by any ethics commission. So that's important to remember as well. But I certainly wouldn't have done those things. No doubt that it did impact the population to some extent. I agree with you, though. It's certainly going to be more focused up in the area of the alleged crimes.
I did think one thing was funny, and this was along the same lines when because I do enjoy your sarcasm at times. When I said that you were discussing Sheriff Peterson's ridiculous quote about it would have been easier to kill Steve Avery than to frame him. And I loved your quote that said, but at least the people of Manitowoc, Wisconsin can rest easy knowing that their elected sheriff has considered and weighed the relative difficulties of both framing and killing one of its town citizens. I was like, I love that because it's just.
It is, it's sarcasm. Isn't it true?
Yes.
I couldn't believe when I heard that. It's amazing what sometimes people will say in front of a camera.
Not to mention it's not true, because if he would have killed Steve, his estate could have still continued on with the lawsuit.
Right.
So it's not even a true statement on top of everything else.
Right.
But really, that's the best you can come up with is that, it'd be easier to kill him than to frame him. Well, okay, great. Thanks for telling us that.
Speaking of, I wonder what, Rule 1.9 I mentioned, Rule 1.6 refers to talking about your current cases. I don't know if that applies to prosecutors or not. I imagine they would argue they don't actually have a client. Their client is the state. That's a client, but it's not an individual or a person. So I don't know. And that's just to jump back into your previous topic. There's something else to throw into the mix. These ethics rules are a real mess. And I think the point of my big take on all of this is that, look, with all those exceptions, the rule might as well not exist about not disclosing a defendant's or suspect's statement. I think that's a problem. The ethics rules can be overly draconian in the case of you can't discuss the public aspects of your closed cases, defense lawyer. But on the other hand, there's ways to do what Ken Kratz did, and it's not an ethics violation. So I think that just shows how these ethics rules are either way too broad or way too narrow.
Right. Because that's what it is with Kratz. It's not like he was finally walking a line. I mean, like you said, it was so dramatic and just so over the top that it was like, wow, like how are you not like negatively influencing everybody that's watching this right now against Steve?
Yeah, the drama of it, and I point out the timing of it. Again, I'm going from memory here. You and your listeners will know much better than I do on these details and facts, but I think the ink could barely dry on the police report before he was in front of that camera. So I remember him saying something like, "The evidence now shows." Well, the evidence all contradicted the statement. So he kind of rushed into it too. That's my personal criticism of it. Is I think he kind of rushed into the whole thing.
Well, and you can't even use the excuse that it's for public safety when you have the people in custody.
Yeah, there doesn't seem to be justification for going that quick, other than maybe swaying public opinion, I suppose.
Well, that's exactly what it was about.
Yeah.
And so going along those types of lines with pretrial publicity, well, first off, is there such a thing as being innocent until proven guilty anymore?
Well,
I know the idea is supposed to be there, but
that's the theory of the law. I'll jump to kind of an issue I'm working on now. Let's say you can get the jury to maintain that presumption of innocence. It's difficult to do psychologically. I don't know. It causes you to have to compartmentalize a lot of things and really work at it. I think we all kind of tend to form opinions pretty quickly. But let's suppose that we get a jury that doesn't know anything about the case. They don't have any prejudices or bias because of the defendant's race or the type of the allegation. So basically, it's people like you and me, maybe, on the jury. Wisconsin, and I might not be answering the question you were kind of hinting at, but I'll jump to my little project anyhow. Wisconsin has a jury instruction.
This is coming next, so you're fine.
We're fine. All right, we'll go right to that.
Yeah,
I guess
it's going to be the next part.
And the presumption of innocence are interrelated anyhow. Right. So we get the jury is instructed on the burden of proof in Wisconsin, but we have a very bizarre burden of proof. The Supreme Court of the United States says, well, the Constitution requires that burden of proof be proof beyond a reasonable doubt. So there's multiple burdens. There's suspicion, there's reasonable suspicion, there's probable cause, there's proof by the preponderance of the evidence, there's proof by clear and convincing evidence, which you might use if you're trying to terminate someone's parental rights or something. And then there's proof beyond a reasonable doubt. And our Wisconsin jury instruction is very defective in several ways. But then it concludes, after explaining reasonable doubt in ways that have been proven to lower the burden, it then concludes by saying, but you're not to search for doubt, you're to search for the truth. So what that does is it pits the reasonable doubt standard against against the truth. And what it does is it allows the prosecutor to say, whenever the defense lawyer argues that the state hasn't proved its case beyond a reasonable doubt, the prosecutor can completely eviscerate that burden on rebuttal closing argument. They say, look, the judge just read you instructions. You're not supposed to search for doubt. You're supposed to search for the truth. And that gives the prosecutor, puts him or her squarely on the side of truth. And it paints the defense as this person who's trying to create reasonable doubt out of nothing. So there's empirical evidence to demonstrate that. And I think common sense demonstrates that if you're going to instruct a jury on reasonable doubt and then tell them not, but in the end say, well, but don't search for doubt, you're going to lower that burden of proof. And I've conducted some empirical tests with Larry White, the psychologist at Beloit College, and we've demonstrated that. So in Wisconsin and in some other states, but Wisconsin is the worst instruction I've seen. I don't think we actually have that high burden of proof in this state. And the burden of proof is only as strong as the judge's instruction to the jury. I would much rather have a lower burden of proof of clear and convincing evidence and use that jury instruction, because that in practice would provide a higher burden of proof. Not in theory, but in practice it would. So I think that's another big problem in Wisconsin, and certainly was a problem at Avery's case. That's the jury instruction he got. And I don't have a memory of reading Dassey's jury instructions, but I think he got that same instruction.
Yeah, that's pretty much the pattern, jury instructions. And
it's the pattern instruction. Judges can deviate from it. Since we've been able to, Larry White and I have published these studies, Wisconsin defense lawyers have convinced about 20 trial court judges that I know of throughout the state to modify that instruction. So it is the judge's individual obligation and responsibility to make sure that the burden of proof instruction accurately conveys the high burden of proof. 20 or so judges that I know of have agreed with me and have modified that instruction in some way, not always the way I would exactly modify it, but they have modified it, and that's currently being litigated at the state Supreme Court right now as well. But that's kind of tied in with the presumption of innocence. So to answer your question directly, I think it's difficult to maintain a presumption of innocence depending on the particular juror, the type of the charge that's being litigated. And then I think I'm more confident that the burden of proof instruction in this state is defective and communicates a much lower standard of proof than what is constitutionally required.
I don't know if this is really terrible of me, but I believe it or not, a couple weeks ago, my daughter was serving jury duty, and the first thing I told her was, "Don't believe that jury instruction."
Yeah, well, parts of it are absolutely clear.
It was specifically when they say, "You are not to search for doubt." I was like, "Don't listen to that."
Yeah. The parts of it certainly are accurate. So the state has the burden of proving each and every element of the charge beyond reasonable doubt. It's what comes after that's really problematic. And one of the things they do is they subtly shift the burden away from the state to produce proof beyond a reasonable doubt, and they shift it to the defense to establish reasonable doubt. And then they go on to tell you all the kinds of doubts that are not reasonable ones. And what that does is it sends a clear message. Well, if you have a doubt, chances are good that it's not a reasonable one. And then as if that's not bad enough, then they conclude with that famous line about you are not to search for doubt, you are to search for truth. And the instruction itself is bad enough, but the license that it gives to prosecutors in closing argument, that's the real harm of the instruction. And it's a disaster. I hope our Supreme Court, I don't know if they're going to reverse the defendant's conviction, but I hope they exercise their authority to terminate this instruction, particularly the part about not searching for doubt. Other courts have held, Washington court, for example, says examining the evidence for reasonable doubt, that's exactly the jury's duty. So Wisconsin blatantly contradicts that, and I hope our Supreme Court will at least change the instruction going forward and terminate that unconstitutional language.
Right, and because of that jury instruction is why Kratz was allowed to say, doubt is for innocent people.
Yeah, he's kind of got a circular argument there. He wants you to, Avery's guilty, therefore he's not entitled to reasonable doubt. Well, he's putting the cart before the horse. He wants you to assume the very thing that he has to prove, but he really doesn't have to prove it because the instruction tells you to search for the truth, not doubt, and it's just a convoluted mess. Now, how much thought jurors give to that, it really depends on the case. You're going to have some cases. I've had jury verdicts come back not guilty in as little as my quickest one was 16 minutes. This case had, just a disaster for the prosecutor. In those cases, it really doesn't matter what the burden of proof is. You could have put the burden of proof on me to prove the case by preponderance of the evidence, and the verdict would have been the same. So, in some cases, but the judges cannot instruct the jury improperly only to hope that the evidence is really, really strong or really, really weak. A lot of cases are going to fall in the middle, and that's where the instruction is really important. That make sure that we hold state to that high burden of proof.
Right, and the word truth is very funny in our system because you have investigators who are supposed to be searching for the truth. You have prosecutors and judges in a courtroom who are supposed to be searching for the truth. You have expert witnesses who use the scientific method because they're supposed to be looking for the truth. And yet all you end up getting is tunnel vision and judicial misconduct and
right.
and just this covering the state's butt and protecting the verdict. Those are that's what you get instead of the truth.
Yeah, there's a nice article by Keith Finley. He's a clinical type professor. I hope I'm not misstating his job, but he works at UW Law School, and he wrote a nice article about rethinking the search for the truth. The system's really poorly designed to get to the truth. It hides a lot of things from the defense. We don't have discovery procedures. We can't take a deposition. The state has exclusive access to things. Now, jumping ahead to trial, we even have several truth-suppressing trial rules. One of them is Miranda, although it's very difficult to get a statement suppressed because of Miranda. So if you flip it the other way and you look at all these truth-suppressing trial rules that benefit the state, we got the third-party guilt rule that's very difficult to satisfy. We've got the victim advocate privilege. We've got the rape shield. And that's a case where there's a great case where a defendant the prosecutor argued in a child sexual assault case that, well, where else could the child, and this is a teenager now we're talking, where else could this child have gotten this knowledge if the defendant didn't do these things? Well, the defense wanted to answer that question. The child was a sexually active child, but that was kept out under the rape shield, not because it was irrelevant. It was highly relevant to the issue of guilt or innocence, but it would impact the witnesses. They call them victims already. They would impact the victim's privacy. So they presume the person's telling the truth, that the person is a victim, and that this would violate their privacy. Therefore, we're going to put that person's privacy above the search for the truth. And then guess what? You get to the jury instructions, and it tells the jury to search for the truth. It's just flawed in so many ways, and we're clinging to this medieval concept of telling the jury to search for the truth when back in the days when jurors were called to court because they literally knew things about the case and literally had to offer testimony. There was a completely different role of the jury going back several hundred years, and yet this concept has been a holdover, and it's being abused today by the state in order to win convictions, is what's happening.
Right, and so that's why we kind of come full circle to the part where it's like, what does a defendant have to do to win when it seems like no matter what they do, the system is set up against them to make sure he loses?
Yeah, the thing I always tell clients is, or the way, not that I tell clients, the way I think about a case is I always think, how can a judge prevent me from putting on my evidence? And can I win this case if I had the burden of proof? That's kind of the way you have to look at it, and those are things you have to consider. If I know that way, well, this is so simple that the judge isn't going to be able to deny me my right to cross-examine the witness, for example. Or the judge can't deny me my right to call an eyewitness. Some things are so basic that they're very unlikely to get botched up at the trial court level. And if I think I've got a very strong case and I would prove it anyhow, then I feel a lot more confident in going to trial. So I don't think the ideals that we had when forming this system and the ideals that we still preach today, I don't think those are still in effect as a practical matter.
Now, this is with the issue. And one of the other words that I hate a lot is sufficient.
Yeah.
And with Steve right now, one of the big issues is always procedural bar. And it says, if you can give sufficient reason as to why you didn't raise this claim earlier, then you're not procedurally barred. But of course, it doesn't say how much is sufficient. It doesn't say what kind of, excuses will do. Like, how do you get over that? I mean, do you know, of certain excuses? Because I know Kathleen was trying to use, lack of legal acumen, the fact that and I know I've never seen this work before, the fact that his prior petition was pro se, therefore he shouldn't be punished for advocating for himself because, now he has an attorney, just stuff like that, which seem to make sense. They seem to make sense that a person shouldn't be punished because they were trying to advocate for themselves when they clearly can't do the same job as an attorney. So when an attorney comes along, it seems fair that they should be able to then put on a proper, a petition, or whatever. But that's not how it works. So, I mean, what does somebody have to do to get over that? What does sufficient reason mean?
Just to draw an analogy to an area I see more often is the interstate speedy trial law, where a defendant is supposed to provide, if you're in custody in Minnesota and you've got a Wisconsin case and you want to be brought to trial, and you have to do certain things. And I'll often argue, and by do certain things, I mean you have to provide certain information, make a certain type of request. And in fact, it would be the Minnesota prison responsibility, the prison's responsibility in this example, to do those things. And often they don't. That out-of-state prison will fail to do these things. And then I'll end up arguing when the defendant's actually brought here, well, he's not a lawyer. He didn't know how to do these things or get these things. He complied in a substantial way as best as he could. And then often the judges are very unforgiving of that. And I think the reason goes back to, remember the courts are looking for that. They want that predetermined outcome. In the case of appellate law, it's finality. They don't want to keep revisiting things. They just want to close the book on things. When you're when you're an appellate court judge, that seems a lot more appealing than the searching for the truth, if you will. That's another limitation on truth seeking, is this idea of finality, even though we learn things after the fact. I mean, how to make a good case for that to get past that bar, and the case name is, I've seen it a thousand times. What I see most often when reading these appellate court decisions is that they'll often say, well, they'll address the issue on the merits and deny it, and then that kind of dispenses with the whole issue. I don't know how you would get beyond that other than, well, what have prior cases recognized as good reasons or sufficient reasons for not doing it earlier? I mean, certainly I would imagine like newly discovered evidence, if that's not a separate doctrine in and of itself, that would certainly be, a good reason. And certainly the ones you raise sound like logical ones to me, but not practicing appellate law, I don't know exactly what the law is as far as what constitutes as, sufficient reason and what would not. But I imagine the problems there parallel the same problems defendants have when trying to invoke their interstate speedy trial rights when they don't have a lawyer. Because if you're not brought to Wisconsin yet, you don't have a lawyer. You have to act on your own. And that's kind of a similar situation, but at the trial court level.
Right. Let's see. I think I've kind of covered a lot of what I wanted to cover. Now, before everybody asks, okay, Mike already told me that he is not up to date on the current case, because I saw some people already asking questions. So I was like, okay, if I don't ask those questions, it's because he hasn't had a chance to really catch up on everything.
Yeah, I've kind of fallen off a bit afterwards. Because it's not, to me, it's not the big earth-shattering thing that it was. We talked about this at the beginning. It's not the big earth-shattering thing. To me, it was a vehicle to expose people to the legal problems in Wisconsin that are happening all the time. Right. So this isn't for me, it's not it's an extraordinary case where I'm tracking and I appreciate people who do. I think it's great that people do that. And the reaction to this case has been phenomenal. I'm just not in that camp of people who are following all the factual developments or the tweets or the, every appellate court, motion or every post-conviction motion, things like that.
Yeah, that would be us.
Because it's just kind of run-of-the-mill to me, so it never really jumped out as this is a unique thing that needs to be followed.
Right. And, I mean, we do that. I mean, we do, like, pour over everything just because I don't even know why. It's just interests me. I don't know. I found it very interesting. And I was actually a lot like you. When I watched Making a Murder, because of my background, it was actually very surprising to me how much of the online community was about guilty or innocent. Because when I watched it, I looked at it completely as, wow, like we have a huge, like a systemic problem with our system. And that's what I took from it. And then when all these people were fighting about whether he was guilty or innocent, I was like, oh, I didn't even really think about that at first. I was just like looking at how messed up this system is, because there was a problem with everything. Every single piece of evidence in this case had some type of problem with it. And even stuff we find now is the same way. Everything we dig up now still has a problem with it. It'll be something as simple as, like just a wrong date or something. But it would be like, why is everything questionable? Why can't anything just be correct with this case or make sense? And that's why it holds our attention, and it also makes us very crazy, but it holds our attention because of that, because it's just this puzzle that, we know that we, probably won't ever completely solve it, but, we want to try to make sense out of it.
Yeah, and I mean, there is some appeal to me in that regard, like I did read, I have done some study of it after writing the book. I read Zellner's very lengthy post-conviction motion. The part that interested me, my first thought was, well, a lot of these criticisms of defense counsel are just not going to fly, and part of that is, as a defense trial lawyer, I was probably a little bit overly sensitive to that, but I thought some of the criticisms were not realistic ones of the defense lawyers, so I fall into that camp where I think they did a bang-up job down there, given their resources and what they were facing, and really, I don't know who could have done better. There's just so many snap decisions you have to make and so many choices to make as you're going through a trial that I thought they did, from what I know about it. And I read probably all of at some point, the pretrial motions and the trial-related documents. I thought they did a great job. But the one thing that I did really find interesting in her post-conviction motion was about the third party suspect. So
Right.
I've got to say, part of me too wants to know, who really did this. I think there's, I maybe don't feel as strongly as some of your listeners, or maybe even as you, but I certainly do think there's more evidence of innocence than
Right.
guilt. That's for sure. For Avery, and I think that if I were to bet my car or whatever else, I would certainly bet on innocence. And I just don't have the strong opinions that a lot of people do, but I certainly fall into that camp. And I'm really curious to some of the third party suspects, and I would like to see things. Really, I'd like to really find out the same things you're wondering about and want to know about. I'd like to see that too, but I don't know if that's ever going to happen.
Right. I mean, obviously, we all want there to be something, but it seems like every day there's just more questions. Not no answers, but more questions.
Right.
And one of the things that I've told people all the time is that, and and obviously I follow this case, but yet I still get frustrated at times because people are so personal and so close to this case that every time something's ruled against Steve or Brendan, it's like they're just out to get them. They will do anything, like they will do anything to keep them inside. They'll do that. And I always say, wait, that's what it's like for every prisoner. It's not just Brendan and Steve. I mean, like, we take it very personally because these are the guys we care about. And so, of course, we're looking at through this lens of these guys are never going to get a fair shake. And I'm always like, almost no prisoners get a fair shake. Like, the system is not designed for them to get out of prison.
Yeah, it's really pretty much designed to keep them there. Once you're in, it's really extraordinarily difficult. And, we saw that with Dassey's foray into the appellate courts, even into the federal courts. Even getting into the federal courts is tough on a criminal case from state law due to that AEDPA.
I was just going to say, like, how much do you hate EDPA? Yeah.
Yeah, what a disaster. I'm really sad, too, that it was signed into law by Clinton, if I'm correct on that. I liked Bill and still do, but that's really too bad. I mean, a lot of these laws, they have unintended consequences, probably no one, anticipated this or expected this. And I think you even saw that. I thought the application of it to Dassey's case by the majority of that Seventh Circuit Court was really crazy. I think you saw, the dissenters, I think, had the better analysis on that, but that's a different story. But
that's a situation again, though, where we look at it, and I mean, just collectively, everybody. And how can you have these judges this was such a polarizing opposition. Like, the one side was like, this is disgusting. These investigators made my skin crawl. This is a huge miscarriage of justice. And then you have the other side saying, like, no, we don't really see anything wrong with this. Like, how are you that far apart?
I think here's a situation where before I said, well, you can't really find lots of explanation. I think here, you want to give the benefit of the doubt, you can, and it's the AEDPA standard, because they're saying, maybe the majority there is saying, well, our issue isn't, is he guilty or innocent? Our issue isn't, was the confession coerced? It was. I mean, you could say that and still rule against him, because under this standard, then you're getting down into this really bizarre standard of, could any reasonable judge, agree? And that, if that's the issue you're deciding not the main issue or even the sub issue, but like the sub issue on a highly technical grounds, it's just a disaster of a standard. I think if you were to give those judges the question of, well, was it coerced? If you're at the trial court level and you have to make that decision, how would you vote? And I think there he would have won if you get rid of the AEDPA standard. Now, that's speculation, and that's giving them the benefit of the doubt. I still don't see. I certainly there feel strongly. I would have been with the minority of judges, or the razor thin minority, and said that that's a violation of the AEDPA, and that's just a bizarre way to look at precedent. I think they did not. I think that they failed him there, and I think the first Seventh Circuit decision had it right, and the dissenters certainly had it right in that case.
Now, I know what you're going to say. I'm looking at some of the questions, and I actually know how you're going to answer this one. But they said, can you ask him if the Denny threshold might be too high currently?
Yes. The biggest problem with Denny is the motive requirement,
right? Because
the state's not required to prove the defendant's motive, but the defendant has to prove the third party's motive. So there was even a case I cited in the Avery book. I think I put it in there. Certainly, it's in my article, which you can find on my website. Which even a case where the defense had DNA DNA evidence of an unknown male on the murder weapon, they still, because they couldn't show motive, they couldn't put on the defense. So yes, way too high, way too high.
And I know that you did put, that's why I was laughing about it, because you have a whole section at the end of your book saying what you would like to do, what would you like to see changed with that, with regards to with the third party liability or the wrong person rule, yeah.
Oh yeah, that's certainly one of them. The jury instruction, we got to change that. We have to relax that Denny standard, the third party guilt or wrong person defense. Those would be two courtroom rules. Certainly, that would be at the top of my list.
Now you are working. You're currently working on this jury one, right? Or are you working on both of them?
And my work on that is pretty much done. I did some on the jury instruction. We did some empirical tests, controlled experiments. Larry White and I did. We published those. I published several follow-up articles based on arguments that prosecutors were making throughout the states. Throughout the counties of the state. When defense lawyers would raise this issue and cite the studies, prosecutors would raise many frivolous arguments. So I wrote some follow-up law review articles debunking those, and it's out of my hands. I've done all I can, and it's in front of the Wisconsin Supreme Court right now, hopefully to change the pattern of instruction.
So now, I talked to you about this, but I was saying, is there anything collectively that we can do? Because I'm not a believer in online petitions. I don't think they do any good. I tell people, write your congressman, write your assembly person. That's what I think, that's the only thing I can think to tell people. What else can people do? Because that's one of the problems. Everybody feels so helpless.
Right. Yeah, I don't, this is a bit outside of my range because I don't, oddly, being an accountant before, I don't know a ton about government processing. You certainly don't need to be a criminal defense lawyer. The things I've done from a legal reform standpoint is, with regard to that Ethics Rule 1.9, I've launched a Supreme Court petition to change that rule. That's a Supreme Court rule, so you have to go through the Supreme Court. Mm-hmm. With regard to the jury instruction, that is, I did with Larry White the empirical evidence, and that involves motions at the trial court level, and now a different lawyer did the appeal. As far as legal justice reform, say for I guess you first have to look at what it is you're trying to reform. Like my next project is the preliminary hearing in the state. We now use, the state is now allowed to use hearsay evidence, so they've abused that to such an extent where they're picking a person who knows nothing about the case and they're merely reading the criminal complaint into the record at the preliminary hearing. So the way I'm attacking legal reform in that regard is I know a local legislator, because the preliminary hearing is a statute. I happen to know a legislator, and there are many legislators who are interested in legal reform. So I'm writing a law review article right now addressing the abuses by the state, and I'm also rewriting the statute. I'm basically doing that focused toward the audience. The audience is a legislator, so I'm rewriting the statute, and I'm putting it in the form of a law review article, and hopefully they will look at that. Other legal reform initiatives, that's how I attack it. Everyone's got to do it differently, and it depends what you're trying to reform. Unfortunately, I can only do what I know how to do as a lawyer. I don't know much about the legal process. I suppose, a way to look at it would be to contact your different representatives. There's one law right now that's deeply flawed. That's legal reform in the other direction. It's called Marcy's Law. You can find out about that disaster of a bill on the Wisconsin Justice Initiative website, and they might offer different ways of how you can try to stop some of those provisions going through to change law in a positive way. I imagine if it's a legislative fix, you would go to the legislature. If it's an issue of case law, I don't know how you would do that short of litigating it in the courts. So there are different approaches based on what you're trying to reform, I suppose, and that's how I've done mine. One was a Supreme Court rule, which required a petition to the Supreme Court. Unfortunately, that failed by one. We had 3 dissenting votes in my favor, but that failed. The jury instruction issue is now ultimately brought before the Supreme Court of the state through another lawyer. We'll see how that turns out. And then my next step is to work on legislative reform for the preliminary hearing, so that'll be directly to the legislators. Okay. So it kind of depends what you're trying to change, and then that's the avenue you take. Before the Avery case, I should say after Avery's first case, there was a big surveillance reform in the legislature. So I think that would fall into the camp of what you were suggesting. Contact your representatives,
Right.
because that's a legislative issue. So it kind of really depends what kind of reform you're looking at.
Right. Well, Julie, have you kept up with any questions at all?
Yes, sorry.
Okay.
There was a question that was for you.
Oh,
But I don't know if he might have an opinion on this.
probably.
Rhonda asked, do you think that since Stephen beat the prison sentence once, the drive to not allow that again for the same person is intensified?
Mike, you can answer that.
You have to repeat that for me. I couldn't catch it all.
I'm sorry. So maybe I'm not talking loud enough.
Oh, I don't have it in front of me. She actually had it in front of her.
Oh, I'm sorry.
Okay.
Do you think that since Stephen beat the prison sentence once, the drive to not allow that again for the same person is intensified?
Oh, I see. Well, I don't know in this case because, I mean, he was clearly innocent. I think all but a handful of the Manitowoc law enforcement who were involved in the case, I think except for a handful of them, I think everyone accepts that he was innocent of that. So I don't think logically that shouldn't really impact it, but how people think, that's kind of gets back to what we were talking about before, what sways a jury, who knows? And in this case, what sways the appellate judges, who knows? But logically it shouldn't, because he didn't cheat the system the first time. The system cheated him for many years, and then he an innocent person, the conviction was reversed. So I would think that it would not impact it the second time around.
Well, yeah, but the thing is that it wasn't that he cheated the system, but they looked
Right.
like idiots when he got out. They had egg on their face was my thing, and they don't want to do that again.
Yeah, it's an angle I didn't think. They don't want to look like fools for a second time, especially
Right.
doing it to the same guy. Yeah, that's a great point. I didn't think of it, and yeah, you could be right. I don't really know. There's no way to know.
Right. The other
Question, great point.
I agree. I have never, that's never occurred to me. That was Rhonda South. Thank you, Rhonda, for that fantastic question. Did you guys already discuss the two different narratives for the same crime? Somebody said you did.
About that. That'd be great. Ask them that question. I know a lot of people ask about that.
A lot of people do ask about that, and I've actually had conversations with Travis about it myself because I was curious about it. So if you could talk about why is it okay that Ken Kratz had two different narratives for the same crime and was able to convict two different people of the same crime with two completely different narratives. He said in Stephen's trial, one man and one man alone committed this crime. And then in Brendan's trial, convicted him of helping Stephen. But
yeah, that was, if you look at civil law, for example, a corporation who's if a corporation is raising this appeal in a civil context, they would have protection against that. This is one of those cases where the criminal defendant whose liberty is at stake actually has less protection than a civil defendant. And I've not had this issue come up. What I always do is I'll look for it. In my practice, I've not had this come up, but I'll look for it. Like if there's co-defendants and one has been sentenced, I'll get that sentencing transcript to see if the state's taking inconsistent theories. And then there's a couple things that I would consider doing. I don't know what the law is on this because I've not yet had to dive into this area. But one, I would try and use that statement of the prosecutor in defense of the client in the second trial, if that theory conflicted with what they're saying at his trial. And then an appellate lawyer would certainly look at that in a post-conviction or appellate sense and say, hey, that's some type of a constitutional violation of due process or something, that they're taking inconsistent theories, they're not searching for the truth, they're only looking to win a conviction. And you'll remember better than I will, but I remember writing about this in a book, and I think that was it Buting and Strang that raised it at the post-conviction level, and the court, and there was even good case law for it, but again, that was in the civil context, so the court simply disregarded it and gave the defendant in the criminal context less protection than in the civil context, which shouldn't happen, because in a the civil context, you only can be sued for money.
Right.
Whereas in the criminal context, your life, liberty, and property are at stake. I don't have an answer. I don't recall why it was, what reasoning the court used, but I know that challenge was raised at some point unsuccessfully. It's something I always look for at the trial court level. I don't know how successful I will be if I ever stumble across that situation, but I don't have a logical answer for why they're allowed to do that.
The criminal case law on it is, there's not a lot of it, but it's very, very case specific. Because what most attorneys end up doing is just citing U.S. versus Berger, where they'll just say, like, well, a prosecutor's supposed to be fair. You're supposed to play by the rules. You're supposed to be fair. And Berger is so vague that the courts don't really know what to do with it. So they look at it very case by case. And essentially it's if you could be convicted under the other narrative, then it's not against your rights. Because if you could have been convicted either way. And so that's why I said that doesn't help Steve, because Steve could be convicted either way. Brendan could not be, because Brendan wasn't home.
Was that raised in, I don't recall that being raised at all in Dassey's post-conviction motions or his appeal. And I know it didn't get up to the federal courts.
No.
Do you remember it at all from Dassey's case?
No, he hasn't raised that claim at all yet. And they said he has not filed a 97406 yet. And one of the other things that they say is that, obviously, if you have two people who participated in a crime and one of them, killed the person, but you don't know which one, they can both be charged with it, because you're both engaged in behavior that resulted in a crime. And then there was another case, and I'm not going to ever remember the names of them because I read so many different cases. But
no one remembers case names except for the landmark ones.
I guess I said I remember Berger. So the other one said that it was a very similar situation where one person was convicted as the sole perpetrator of the crime. So the other person had been convicted as well, but then his conviction was overturned. So when he was put on trial again, his attorney did win in the sense that he could not be tried as the sole perpetrator because the other person had already been tried as the sole perpetrator, but he still could be prosecuted as party to a crime, which isn't much better. So
right. Yeah.
So they're kind of all over the place.
One way or the other.
Right, and that's why I said they're so all over the place on it that it's very case specific. So you would have to
I have lunch often with an attorney named Terry Rose, who's been practicing longer than I have, and we talk about the old days of practice when he was just starting out, and they've gotten away from having any type of a firm rule of any kind, because if you have a firm rule of any kind in any context, then people will be acquitted or they won't be able to be charged or whatever it is. All these exceptions and nuances and counterexamples and all these things, they all come up when the courts are struggling to find ways to uphold a conviction. And that's just another example. It seems that's a recurring theme that you can find in any area of law. The most recent one I remember, I should just say, for any of the articles I've been mentioning, you can find them at cicchinilaw.com. That's my website. And I also have a blog, thelegalwatchdog.blogspot.com. I haven't written on it for a while, but I remember writing a post on there about the dangers of thinking there's a general rule. And it was the same thing. There used to be what we thought was a firm rule that statements made to your probation agent can't be used against you at a trial because those statements to the agent are involuntary. And then they came up with this bizarre exception.
Wasn't that the Fair case?
Pardon?
Wasn't that the Fair case? Michael C. Fair? I thought that was his case.
That sounds familiar. No, I think this was didn't have anything to do with either of the. I think I remember the Fair case from Dassey's case. Again, I'm with you. I don't remember names.
Yeah, it was a similar thing.
Pardon?
It was a similar type of scenario.
Yeah, the one I'm thinking of is pretty recent, and they just created this bizarre, except so we can't even rely on that general rule anymore when advising clients on different things. It's so hard to come up with clients ask a question, there's almost never an answer because there's a million exceptions. So that makes it difficult, and it sounds like that's the same thing that's happening in this context of these dual prosecutorial theories.
Now, what do you think about the Wierski ruling?
I'm sorry, which one?
The Weierski ruling about Brady, the recent Supreme Court decision about the Brady doctrine that they just kind of turned on its head after about 50 years.
Yeah.
Do you think that will actually change
anything? Give me the
anything?
background of it, because I know I read all of these, and a lot of them, if they don't seem to have an immediate impact, they don't really stick in my head. So give me the background.
Well, essentially, I mean, the bottom line was that they just said that they want to stop. The Supreme Court said that they want to stop putting the burden on the defense. It should be more about the prosecutor's misconduct than the defense's lack of due diligence. Okay. They want to switch the burden back to the prosecution. And a lot of people didn't like it, obviously, because this pretty much went against, like I said, like 50 years of jurisprudence when it came to Brady. And you know, I was just wondering, I figured defense attorneys have to like it. They have to like that.
Yeah, I remember seeing, and I've also got we get little summaries of these cases as well. And I certainly, this is the type of thing when you're practicing, you're gonna read it, it's gonna go out of your head, and then when you have one of these issues, then it comes up in the research. But if you're toward that same thing, something popped into my head, and that's the lost or destroyed evidence. And I know this is an issue with the bone evidence, and you see this in a lot of cases. There's in some instances they will even put an impossible burden on the defense. You have to, in the case of lost or destroyed evidence, you have to show that the evidence was exculpatory. But if it's lost or destroyed, how are you going to be able to do that? So some of these burdens that are placed on the defense are absolutely absurd. So I'm going to have to go and revisit that case, but unfortunately I don't have a working knowledge of it in my head. But yeah, the more we can shift the burden to the state to actually comply with the rules is obviously better. What you find in these court decisions over the past many years, certainly since I've been practicing, is always ways to look to excuse the misconduct or the failure to disclose or the improper argument. It's a theme that just runs through the case law repeatedly.
Well, the reason I brought it up, the reason I thought about it, was because Kathleen Zellner did actually cite it. And I said, I think she just couldn't wait to cite it. She cited it in her most recent filing coincidentally, when it came to destruction of evidence. And she wanted to use the same argument that even though it's not Brady, she wanted to use the same argument though, like why is the burden on the defendant, here? Why is the burden not where it belongs on the prosecution? And I think that, this it's going to be a tough one to win just because there's never been a case in Wisconsin where they've ever said that law enforcement acted in bad faith. It's just another situation where they always can say, well, it was a mistake. There was incompetence. It was negligence. But they've never ruled that it was bad faith. Not in a second.
And that's that. I think the case is Green for the lost or destroyed. It's a disaster. This would be a perfect way to reverse it. But we in Wisconsin, and this is something probably to greater or lesser extent is elsewhere as well. But we have a history of, even in other contexts, even intentional misconduct. We will put the blame on the defense lawyer. Prosecutor misconduct at trial. Well, defense lawyer didn't object at exactly the right time, or didn't request for a sufficient remedy, or requested a mistrial too soon or too late, or not at all. And we don't go to the source of the problem, which is the intentional prosecutor misconduct. Instead, we look for ways to put the blame on the defense lawyer. And it seems like a common theme that's running through the production of evidence as well as misconduct during trial.
Right, and that's the exact point she's trying to make. She just keeps saying, like, they keep doing this over and over and over again, and they should not be continued to, be rewarded for their misconduct, for their bad behavior.
Reluctant to change that stuff, and her argument reminds me of a great case in Florida, like you do. I can't remember the name of this case, but I cited it in one of the articles on prosecutor misconduct I wrote, and the defense lawyer said, look, the same prosecutor keeps making the same improper argument in closing arguments. And you said in the Jones case, in the Smith case, in the Johnson case, and he listed all these cases that sooner or later you're going to have to reverse to get the prosecutor to stop doing this. But courts do not want to use the appellate case to deter future misconduct. So the court once again issued an empty warning and said, well, if this continues at some point in the future, we may have to reverse one of these convictions, teach the prosecutor the lesson. So if they ever do that, I certainly look forward to the day, but it's the same empty threat over and over. And the case law, it just protects the prosecutor. In your case that you're discussing, and maybe negligence or failing to preserve, and in other cases, it's outright affirmative misconduct, and they are protected.
Okay, so Julie, is there any other questions that you wanted to ask, or that other people want to ask? Because we got to wrap it up soon.
I don't have a question, but I wanted to make a comment.
Okay.
After hearing Michael, when he was talking about, a little bit about who he is and his background, I feel like I'm doomed because I am going to school right now to get a degree in accounting because I want to be a business attorney. I want to do like contract law. And when I first met with Eric Jose and I went on his channel, he was talking to me about how Laura Nyrider was going to be a business attorney. And then she ran into Steve Drizzen and decided to do criminal defense law. And now Michael is saying the same thing. So I feel like I'm dooming myself to be in criminal defense.
Well, the good news is we're still a pretty small sample size, so there's still hope for you to escape your fate. But yeah, who knows? Maybe you'll wind up there, but certainly don't have to. You'll live. If you do, you live a more exciting life, but less peacefulness and less calm.
Less calm, right? Exactly. Thank you so much for being on. I know it's not my channel, but this has been really informative for me, and I think for everybody else. I really appreciate you doing this.
I appreciate
Tracy
you,
Michael.
Tracy, calling me and having me on. It's been a lot of fun. I do have to wrap it up in a couple minutes, but you should send me you can email me a link later. I'd like to check it out.
The video here?
Yeah,
okay.
Yeah, the YouTube channel, or if there's a specific link you can send me. Otherwise, I can search for it. But I think I mentioned before, I'm a bit of a Luddite. I don't really don't have the technical savvy that you guys do. But
well, I've been on for 5 hours, so I'll make sure to tell you where you can start listening.
Great. Well, yeah, and then I'm going to do. I had a lot of fun. Thanks for having me, and keep up the good work. And I'll watch your email.
I just want to tell everybody again, the book that we talked about was Convicting Avery, The Bizarre Laws and Broken System Behind Making a Murder. So that's the book that we were talking about. And then he also wrote Anatomy of a False Confession, which covers, obviously, Brendan's case. So check for that. We've actually been putting up your links, or my mods have actually been putting up your links the entire time. So we're set.
Excellent.
Yeah.
All right.
So, well, it was very good to talk to you, and I really do appreciate you coming on and spending so much time with us.
Yeah, my pleasure. Thanks for having me.
All right. Thank you.
Okay.
Bye.